Welcome to my channel. In this video we are going to be talking about the second part of enforcement of members' rights, and this is enforcement of members' rights under statutory law. In our previous video we talked about enforcement of members' rights under common law, and it was through three ways, that is personal action, derivative action, and then representative action. So in this video we are going to be talking about the enforcement of members' rights through the statutory law. Enforcement of members' rights through the statutory law can be done in three ways also. First is winding up the company under just and equitable clause, then by using the operation section, then through inspection and investigation. Then we are going to look at each one of them in details. The first way of enforcing for members' rights under statutory law is by winding up of the company under the just and equitable clause. A company can be wound up if it's just and equitable to do so. If it's fair to dissolve it, it can be wound up. But before the shareholder can have the matter entertained under this section, he must satisfy the following conditions. First, he must petition to court that the company should be wound up for just and equitable reasons. And then the petitioner must be a contributory. He must be a shareholder who is liable to contribute to the assets of the business during the winding up. Then he must satisfy the court that although there is another way open to him, he is not acting unreasonably. He is not seeking the other way instead of winding up of the company. Even though the other solutions, he thinks that winding up of the company is the best option. Then the petitioner must satisfy the court that after winding up, there would still be something tangible for sharing among the shareholders. And if the company is heavily indebted or insolvent, then it can't be wound up. Let's look at the kinds of wrongs that can be entertained under the just and equitable clause. The following have been accepted as major grounds for winding up the company under just and equitable clause. And first is when there is a deadlock between directors who are the only shareholders. And this was seen in the case of Riendige Tobacco Company Limited in 1916. Chancery Division 426, whereby two directors who were the only shareholders hated each other so much that the company had to be wound up. So when there is a deadlock between directors who are the only shareholders, the company can be wound up under the just and equitable clause. Then secondly is loss of a substratum of the company, whereby there is loss of the object for which the company was formed. Where a company was formed for an illegal or fraudulent purpose, it can be wound up under the just and equitable laws. The second way of enforcing for members' rights under the statutory law is by using the operation section. Operation section, where one of the members of the company is oppressed, the member can complain to the registrar under the operation section, and this is according to section 247 of the Companies Act. Here the petitioner may be complaining about operation, not only about to himself, but also to the other shareholders. And this was seen in the case of Elder versus Elder and Watson in 1952. And court defined operation as a visible departure from the standards of fair dealing and violation of the conditions of fair play on which every shareholder is entitled to rely. So when there is operation, a shareholder can be able to go to court using the operation section. They can report to the registrar under the operation section. And for one to rely on the plea of operation, he must satisfy the following grounds. First is that although the facts justify the winding up of the company, such winding up would be unfair to him. He doesn't wish winding up of the company. And then secondly, where the registrar is satisfied with the petition, he may make an order directing how the company's affairs are to be conducted in future, or order that the petitioner be brought out of the company because he is oppressed. Yeah, the order is for the petitioner only to be brought out of the company, but not other oppressed members. Then thirdly, the petitioner must prove that the act being complained of is not an isolated event, like it didn't happen once, but it was a continuous process. And then lastly, the petitioner must satisfy the registrar that the operation is not only limited to himself, but also the affairs of the company are being conducted in an oppressive manner. And this was seen in the case of Re H.R. Hammer Limited, 1959. A father who gave gifts of shares to sons continued to run the business as his own and to disregard wishes of other shareholders and company directors and even resolutions of the board of directors. It was held that operation amounts to a conduct by the majority which is harsh, burdensome, and wrongful. And the last way to enforce for members' rights under the statutory law is through inspections and investigations, and this can be initiated either by the registrar or the members themselves. Yeah, and investigations by the members may be initiated in two instances. First, by applying to the registrar to carry out investigations. Yeah, the individuals can apply to the registrar to carry out investigations, and this is under section 173 of the Companies Act. And when they apply to the registrar to carry out investigations, they must prove that they are not malicious, like they do not tend to harm anyone, and the application will not be entertained if there are other remedies available, if there are other solutions available. Yeah, it will not be entertained. And this can be seen in the case of Re-Eyereza Bwambale Company Limited. Then another instance whereby the investigations can be initiated by the members of the company is by using a special resolution. A special resolution may be passed that court appoints competent inspectors to investigate the affairs of the company. A special resolution is like a written decision. It can be passed by court to appoint competent inspectors to investigate the affairs of the company. Then let's look at instances where investigations by the registrar can be initiated, and this is according to section 172 of the Companies Act. Yeah, and they can be initiated where the registrar believes that the Companies Act provisions have not been complied with. Yeah. Then secondly, when the registrar believes that the books and documents of the company supposed to be filed do not reasonably disclose what they ought to disclose, like they do not show what they're supposed to show. Here he may direct through a written order for the company to produce all relevant books and documents for investigation and inspection, and if he feels dissatisfied, he can take a report to court. Yeah, and those are the two instances where the registrar can initiate investigations. Let's look at the instances whereby investigations can be initiated by court. Court may order for the appointment of an inspector to look into the affairs of the company if from the registrar's report either the company's business is being conducted in a fraudulent or unlawful or oppressive manner, or members have not given all the information they are entitled to give. And secondly, when the promoters or management are guilty of misappropriating of funds of the business. And the last way through which the rights of members can be enforced under the statutory law is misfacins proceedings. And this is another remedy open to shareholders who want to enforce the rights of the company. Yeah, he's not enforcing his own rights, but the rights of the company. Here, a shareholder who is also a contributory can apply to court for an order to examine the conduct of promoters, directors, managers, liquidators, or any other company's officer or a member who has been guilty of misappropriating or breach of trust to the company. Yeah, and that's what we call misfacins proceeding. Misfacins is like misappropriating the funds of the company. But the limitations to this. The three important limitations to misfacins proceedings, and the first is that the proceedings are only invoked during winding up of the company. Then, secondly, the section deals with only the wrongs involving misappropriation of funds or property. Yeah. Then, where the proceedings are successful, the guilt officer may be ordered to pay or replace the funds or property, or to contribute such sums of money as the company deems fit to the assets of the company. And such an officer may also be liable to criminal proceedings. And that was all about enforcement of members' rights under the statutory law, whereby it can be done in 4 ways. First is winding up of the company under the just and equitable clause, then by using of the operation section, then through investigation and inspections, and lastly through misfacins proceedings. Yeah, and thanks for watching. Don't forget to subscribe, like, comment, share with your friends, and watch my next video. We shall be introducing the third topic in company law, which is raising the capital of the company.